Now, in summary, trusts are advantageous because they avoid probate, but they're also advantageous because they have greatly reduced attorney fees. They're very difficult to contest. Trusts are considered incontestable in their distribution. You can basically contest a trust because you think the trustee is not handling the funds correctly. And there's 3 levels of liability on a trustee to handle your funds correctly. There is a civil level where they weren't diligent, they weren't responsible in handling the assets the best that they could. There's a criminal level, which usually involves some self-dealing with the assets. There's civil liability, there's criminal liability, and there can even be penalties and fines and jail time when it becomes outright larceny. But it's the beneficiaries who keep them honest, and they're entitled to a copy of the document and an inventory of the assets within a period of time after death, and they keep the whole system honest. But other than that, there's nothing to contest. There's no opportunity to come in and say, well, Mom loved me a little better than these other 2 kids, and I ought to get an extra $10,000. That opportunity does not exist in a trust. It's considered incontestable in its distribution. Trusts never have to be made public. You can sue on the terms of a trust in court, start a lawsuit. You have to specifically request the court docket the trust document as a part of public record in order to pursue the suit, and that takes court permission and approval. But otherwise, it's considered a private document. I would point out that in the death of Michael Jackson, there was a lot of talk about the fact that we had his will, but his will was basically what's called a pour-over will. And that's a will that says that when the individual dies, whatever they didn't put in the trust goes in after they're dead and gone, and it always gets put on public record. But the actual trust to his estate, they often commented, we'll never get to see that. We'll never get to really know who the heirs and who the income beneficiaries and principal beneficiaries are, because that's a private document, and it just doesn't get filed. And that's one of the reasons why a large, famous person with a really large estate, they want to avoid the opportunity for people to defraud or to misappropriate some of the assets of that estate. And the family on most estates is going to be able to control and run it. They would do it on all estates, but in larger estates, a lot of times you can hire corporate professionals, corporate trust departments to help manage and operate funds because there's such a large amount that's involved. When you set a trust up, some of the advantages are that the owner and spouse are their own trustees. They have the ability to change or revoke the directions anytime they want. There's no outside reporting. You set a trust up, title your assets in the name of the trust. The car is in the name of the John Doe Trust by John Doe trustee. John Doe can still buy and sell cars. He just signs the title away on the old car when he sells it as John Doe trustee instead of just John Doe. And then when he acquires the new car, he puts it in the name of the John Doe Trust. And as long as you do that, add that extra word on the title, it's in the name of the trust, and it'll avoid probate. Trusts become irrevocable when the individual dies or becomes incapacitated. That means that the power to revoke or amend it is personal to the settlor, and when they lose the power, nobody else steps in and has it in place of them. All we're going to do is change the titles on the assets, and they continue to operate their life the way they always have. It's also very possible within a trust to make arrangements for elder care, nursing home care, nursing home planning, which we will talk about in another video that you'll be able to access through our website. But if you don't have a trust, it's something everybody ought to think about. If there's a portion of this you didn't quite understand, you might want to replay the video. You might want to get a hold of us. But on the website, there's the box to collect the data taker. We encourage you to download that. And what that'll do is give you a website. It'll give you an Excel spreadsheet that's a data taker. If you fill that out thoroughly, we can complete it. It'll ask for specific intentions of the estate holder with regard to their assets, about disability, about special requests and preferences, about businesses on that data taker. And you might want to refer to our video on data collection because we explain some of these things in there, and it helps us design documents. We will actually design a trust package for you. When we do a trust package, it's going to not just include a living trust, but it'll include a pour-over will for the estate holder. If there's a spouse, it'll include the same for the spouse. We'll also provide a power of attorney for everyone, because everyone ought to have a power of attorney. It's a document that appoints somebody to act as an agent of your signature on different types of business transactions, such as life insurance claims or health insurance claims or income tax returns, various business transactions that you may incur. And the attorney, in fact, that's the name of the person appointed in the power of attorney. They act as your agent to sign your name for the individual when the individual estate holder can't sign their own name. We also do life support documents automatically as a part of the trust package, and includes a document that's called a declaration of life support, and it states that it's declaring your intentions of what you want for life support when you can't communicate. It'll include, as a part of that, a power of attorney for a health care attorney, in fact. Some places call that appointment of a health care surrogate, and that's an individual who can make decisions on your life support when you can't make those decisions yourself, usually because you're comatose or incapacitated. And we also do, as a part of that package, what's called a do not resuscitate directive or a medical directive, and ours gets very detailed as far as different conditions of health and different types of treatment that you want to have used or terminated or omitted when you're at a point in your health when you're probably not going to wake up, and they now have capacity to basically keep fresh blood flowing through the body, even though it probably would have died some time ago. And this gives someone the capacity to finally turn the equipment off to terminate the continued life support when, in your opinion, you'll be able to very, very specifically describe, in your opinion, when you want that done. It's important to leave that behind. It's important if you want things kept on to leave that behind, and it's important to leave that behind if you want things turned off, to leave that document behind. It takes the emotional strain off of the heirs and puts it on you to leave them a decision and direction on what to do, rather than them left in a quandary to figure out what they ought to do with mom or dad. And it's probably one of the best emotional reliefs you can give to heirs when they're trying to deal with your loss. We also put provisions in our estate planning. We have a thing called a private contract for home health care, and it's a unilateral agreement by the estate holder to allow any time and expense family members put in providing the estate holder or spouse with time and assistance in managing the affairs of their estate, to put a value on that time, allow it to accumulate on an account at interest like a charge card or revolving account. Well, we really don't want it compensated. What it creates is a lien on the estate as time and assistance is put in. There's a specific Medicaid regulation. We've got a specific video to get into the explanation of all this, but it allows for planning for elder care for individuals as they get older. So we encourage you to look at this and give us some consideration. We'd be happy to work with you and your financial planning team, whether it's attorneys, accountants, or financial planners, in structuring these documents and putting these things together. That's why we are asking for some pretty specific information in our data taker. So we would encourage you to download it, fill it out, and email it back to Foster Estate Planning. Thank you.